Did you know that the United Kingdom has a constitution, but that it's not actually written down in a single document anywhere? Now, US citizens will be massively familiar with the US Constitution. In fact, even if you're not American, chances are you have heard a lot about the US Constitution. But what a lot of UK citizens don't realise is we also have a constitution in the UK. But oddly, it's not actually written down in a single document. So what is it that actually makes up the UK Constitution? Well, in the following short video, we're going to look at an extract from one of our CILEX F1 courses, which goes through what the UK Constitution is and what makes it up. So let's have a look at that video.
So with that in mind, let's now take a look at sources of the UK Constitution, where this unwritten constitution is ultimately derived from in a bit more detail. And so with the UK Constitution, of course, the Magna Carta is ultimately the fundamental start date. Everything ultimately derives from the Magna Carta. It introduced these key principles of the rule of law and the protection of rights and stopped the king from being able to exercise his will without constraint. But the Magna Carta is not just a fancy word. As I mentioned, it does introduce these key concepts that everything was built upon. And that's in turn led to several other important documents that have underpinned the UK Constitution, such as the Bill of Rights. Now, this was introduced many years later. It seems like it was still a huge amount of time ago, 1689, but actually 1689 is pretty much as close to nowadays as the Magna Carta was to the Bill of Rights. And this document, the Bill of Rights, limited the powers formally of the monarchy. So this is where ultimately the creation of parliamentary supremacy came from. You then have the Acts of Union in 1707, and this is essentially what created the United Kingdom. It brought England, Scotland, Wales, Ireland, at a later date, all into one single parliament, balancing those local traditions but with laws for the nation as a whole. Also, the Human Rights Act of 1988. Now, this was originally something to do with the European Union. The European Convention on Human Rights was then essentially enacted in the UK via the Human Rights Act. And this essentially means that UK courts can enforce human rights protections in the United Kingdom. And this goes above, essentially, the UK law here. The European law is above the UK law. And the case that we're going to introduce here, we'll come on to this in a bit more detail, was the case of R v Secretary of State for the Home Department ex parte Daly. And essentially, in this case, a prisoner challenged a policy of allowing prison officers to search their letters, their private correspondence, while they were not present. And Daly argued that this violated his right to privacy. Yes, he's a criminal, yes, he's in prison, etc. But when he's got his own private correspondence, that is not something he should be giving up just because he is a prisoner. Prison officers shouldn't have the right to just read through his personal email. Essentially, what happened was the court agreed that this policy breached Daly's human rights. It breached his right to a private family life, which was an important part of the European Convention on Human Rights. And another source is Acts of Parliament. Now, Acts of Parliament are essentially statutes passed, and they're another pillar of the UK Constitution. They can be used to adapt the government, to adapt to new societal changes. Of course, those are the examples of why an unwritten constitution can be useful. And key examples of this include the Scotland Act, which created the Scottish Parliament, which shared power with the UK Parliament, but it allowed for certain rules, certain laws to be set in Scotland free of Westminster. And also the Fixed Term Parliaments Acts, which set fixed terms, fixed intervals for general elections. essentially meaning that the government couldn't just constantly postpone when it was going to have the next election. So it meant that the government had to call an election within a certain fixed period, otherwise it would be unconstitutional. And this, of course, is all about protecting democracy. It then gives the people the right to elect a different government if they so choose. So we're going to look in a bit more detail about these other key sources of the UK Constitution now: common law, royal prerogative, constitutional conventions, and international law. And we're going to start by looking at common law. And common law is not written down. Common law is all about how laws are developed and changed through judicial decisions. And a key case for this is Entick versus Carrington, 1765. So again, going way back in the past now, all these cases affect the cases we are today, or the situation we are in today. So in this example, or in this case, John Entick was a writer who was critical of the government. And at the time, that could attract a lot of serious attention. You couldn't just talk out about the government in the same way as you can now. And essentially what happened is his house was broken into, searching for writings that were basically speaking out against the government, believing he was going to incite a rebellion and challenge their authority. The problem is they had no legal right to enter his property. They had no warrant. They had no court orders. They were just acting in the government's best interest. But of course, they couldn't do this. And so, of course, he was rightfully outraged. And he actually brought a claim against the government officials for trespass, claiming that they were unlawful. And when the judgment was delivered, it was actually found that the government cannot act outside the law. So just as the Magna Carta said that the king couldn't act outside of the law, this common law case of Entick versus Carrington established that the government cannot act outside the law as well. So one of the foundations of the rule of law here is that, again, it's pushing this idea that absolutely no one, no individual, no entity is above the law, is outside the law. So very, very important case there. And what this does for you today is essentially it still to this date protects you from arbitrary state power. It protects you from the police or the government or whoever it may be from coming into your property without due cause. They must have an actual warrant that needs to be signed off by the judiciary to come into your property. They can't just, well, we're the government, we can do what we want, we're coming in. So very important case there. Another important case to look at is Jackson versus the Attorney General. And this case essentially centered on the Parliament Act of 1949, which allowed laws to be passed without the House of Lords' consent. So the House of Commons creates a law, then it gets assented to the House of Lords, and the House of Lords approves it or doesn't approve it. And this is essentially, this act allowed laws to be passed without the House of Lords' consent. And a challenge arose to this law after the Hunting Act. So the Hunting Act was a law banning fox hunting, which was passed using the Act's provision. So essentially, the House of Commons banned fox hunting, but they didn't want it to go to the House of Lords. They didn't want it to go there because they felt it was going to be rejected at the House of Lords. And so people actually came out and argued that this was not constitutional because it was going against the system, essentially that laws need to go by both the House of Commons and the House of Lords. So the question was, could Parliament limit itself? What was ultimately found was that the 1949 Act was valid, confirming that Parliament had acted within its own powers. Because the Act was valid, essentially this meant that the law could be passed without going to the House of Lords. In their judgment, they basically said that Parliament was sovereign, and so the courts could examine whether constitutional procedures had been followed. And so the courts, in this instance, protected that process, and this protects the integrity of the constitutional process. It also highlighted the importance of the judiciary in the legal process in the Constitution. So going back to our idea of separation of powers. Next one we have is royal prerogative. And as the name might suggest, royal prerogative relates to powers exercised by the monarch. Now, of course, these have since been largely transferred to the government, but essentially it gives the government the right to act without parliamentary approval in certain situations. So this is basically exceptions to the rule of where you've got the whole separation of powers, where the government can act without getting the general approval of Parliament. Now, as you might expect, this is only usable in very specific, limited situations. Of course, it does allow for far quicker decision-making and actions, but of course there is a debate over whether it's even constitutional, and that's why it's limited by constitutional principles, and generally only applies in certain situations, such as appointing cabinet ministers, declaring war, managing specific foreign relations, and negotiating treaties, where of course it would be very time-consuming if it had to keep going back and forth in Parliament. And the reason why these are important, it's important to understand these, is because they are very useful for certain situations, but you do need to be very careful. The government needs to be very careful that it is limiting when it exercises these powers, as of course there is a constitutional impact. And a really important case to represent this and to represent the power and the balance of power in the UK's constitution is the case of R. Miller, the Secretary of State for exiting the European Union. Now, of course, in the Brexit vote, it was decided that the UK was going to leave the European Union. And whilst the public had voted to leave, there was questions over how it was going to be implemented. And essentially the Prime Minister at the time enacted Article 50 of the European Union's treaty. And this is the mechanism for withdrawing. And the Prime Minister, Theresa May, basically said, well, because this is a foreign affair, we will trigger it using prerogative powers. We'll go around Parliament to basically decide ourselves how the UK is going to leave the European Union. And Gina Miller essentially challenged this, saying that this undermines parliamentary sovereignty. Only Parliament can make or unmake laws in the UK. And therefore, by using royal prerogative to go around Parliament, you are basically doing something that's unconstitutional. And essentially the House of Lords actually decided in her favour, as in Gina Miller's favour, because by leaving the European Union, it would give the UK government the possibility, the chance to unmake and undo rights and laws that were enacted upon the UK via its membership to the European Union. And therefore, it meant that you couldn't do that because only Parliament can make or unmake laws. And by leaving the European Union, you are essentially then giving the government the right to make or unmake laws. And so it was found to be unconstitutional to leave the European Union without going through Parliament. So this gives you an idea of what royal prerogative is, when it can be used, and when it can't be used. And ultimately, if it's going to involve making or unmaking laws, it cannot bypass Parliament, as the case of R. Miller shows. Next up, we have constitutional conventions. And constitutional conventions are unwritten rules that fill in the gaps where statutes or common law falls short. So generally, they are not legally enforceable, but they can be politically binding. And we have some examples of this. First of all, being ministerial accountability. That ministers, members of Parliament, must answer to Parliament for their department's actions, potentially resigning when they fail to uphold this responsibility. So if the Secretary for Transport has made some massive fouls, or the Transport Division has made some massive fouls and it's led to all kinds of transport issues, then the Minister for Transport will be expected to resign because they are accountable for that. Also, you have collective cabinet responsibility, where ministers must publicly support government decisions or resign. So this is very important. This is where you essentially stop infighting within your own party. If the Labour government is in power and the Labour government wants to pass a certain law, then all Labour ministers are expected to vote for that law. If you have Labour ministers going out and saying, well, actually, no, this isn't a good idea, I'm not going to sign off on it, I'm not going to vote for it, then you're going against your own party. So that's the principle of collective cabinet responsibility. And also monarch's neutrality. This essentially means that monarchs must act on ministerial advice and remain politically neutral. So the king or queen of the United Kingdom can't come out and say, I don't agree with what the government's doing here. They can't say, well, I don't like this government. I'm a huge fan of the Conservatives, and I'm really disappointed that the Labour government is running the country at the moment. So the monarch must remain neutral. And again, these are really important in maintaining balance and trust in the general governance system. If the monarch is coming out and saying that they only want a government full of these sorts of people, etc., then that's going against the unwritten constitution of the country. And then we have international law as well. So international agreements that influence the United Kingdom's constitution. So this can be things such as treaties, conventions, EU law, other global conventions as well, such as the Geneva Convention with regards to war crimes and war in general and rules of war. All of these are things that impact the United Kingdom. And a key case here to demonstrate how international law affects the UK's laws and constitution is RV Secretary of State ex parte daily. Now, of course, we spoke about this earlier in brief detail. Just going to look at it in a bit more detail here. And this ultimately explored the question of how far a government can go in limiting individual rights of its citizens. So as I said before, Mr. Daly was a prisoner and he challenged a policy that allowed prison officers to basically review his correspondence, to go through his messages. And it was found that the correspondence inspection was beyond what was necessary. It went against principles of human rights, that he had a right to a private family life. And whilst there might be instances where it's necessary to read correspondence if he's colluding with people on the outside and things like that, if it's just his personal correspondence with his family, then that goes far beyond what is necessary. And so the human rights here actually strengthen domestic legal protections, that whilst the UK government may have felt that it was fine to do this, the European Convention on Human Rights said that it wasn't. So a really important landmark case of international laws, international human rights affecting UK law. So those are the general sources of the UK Constitution. As you can see, it's more than just a historic set of laws from the Bill of Rights and the Magna Carta, the Acts of Union, etc. It balances the history, it balances the statutes and conventions with accountability, with the protection of rights from many, many different sources. And that's why we've got such an adaptable constitution nowadays. For better or for worse, some might say that the written laws are still better, but it does allow for the UK constitution to move with the times, to be adaptable, to be flexible.
Now that short clip was taken from one of our CILEX law courses. If you are studying towards a CILEX qualification and you choose Astranti as your training provider, you will get access to a whole lot more engaging and straightforward video content, just like you've seen, and much, much more, including clear study text, mock exams, exam technique, tutor and mentor support. If you want to find out more about our CILEX courses, just make sure to follow the link in the description.